So thank you very much for joining us today on this very important topic. We're going to spend the next hour reviewing our harassment and bullying prevention. This session is geared for our supervisors and above. We're lucky today to have Marian Zapata Rosa join us. She is a partner with SUMCO's employment law firm, Snell and Wilmer. So thank you, Marian.
Thank you, Michelle. Good morning, almost afternoon. I'm going to be conducting over the course of the next hour or so your bullying and harassment prevention training. And an important reason why we're doing the training now, it's very timely for employers nationwide, but also in the new iteration of your harassment policy, we now prohibit bullying in the workplace as well. And so we'll talk about what that looks like. We'll start today's course by looking at some statistics of bullying in the workplace. I will provide a definition of bullying and harassment, lots of examples. We'll talk about the close connection between bullying and harassment, some consequences of bullying for not only the victim, for also the company, and then we'll also look at some case law. The presentation for managers and supervisors is different from the presentation that I give employees, frankly, because there's different information that is really pertinent to the individuals in this room that's not applicable for all your employees. But throughout the presentation, if you have questions or comments, please feel free to shout out so that we're sure to get you the information you need. So starting with some statistics about bullying in the workplace. According to this report, 27% of employees reported that they've been bullied at work. Another 21% reported that they have witnessed it, and 72% of employees are aware that bullying happens, either because it's happened to them, they believe it happens, or they've witnessed it happen to someone else. If we translate that percentage into a number, it would amount to 37 million employees in the U.S. workforce who reported being subjected themselves to some form of abusive conduct, and double that who are affected either because they have experienced it or witnessed it in the workplace. So to illustrate that even further, transposing that number onto the map, onto a map of the United States, 65 million workers would amount to the population of 15 states in the United States combined, of people who feel that they have been bullied or know that it's happening at work. To break these statistics down and distill them a little bit further, we know that majority of the time the bullies are reported to be men. However, when women are bullied in the workplace, they are more often than not bullied by other women than by men. And then, interesting for the individuals in this room, more often than not, the bullies are reported to be bosses and supervisors. So what are employers doing about these? These numbers are really astounding. Your employees probably, like the employees in this study, would similarly report that they've seen it or witnessed it, maybe not here, but at some point in their careers. And so employees are on heightened alert about this kind of treatment, particularly when it's coming from the top down. And what are employees doing to combat bullying? Well, 72% of employers are doing absolutely nothing. Less than 20% of employers are actually taking some affirmative steps to address bullying in the workplace. SUMCO being one of those companies that's really at the forefront of tackling this issue at work. So there is not a legal definition, and I made this clear with employees throughout the trainings in Albuquerque and also this morning and throughout the rest of the trainings today, that technically bullying at work is not illegal. So there is not a federal, state, or local law that prohibits bullying in the workplace. And so I can't provide you with a legal definition of what would constitute bullying and what wouldn't. But I've nonetheless provided a working definition for purposes of understanding the policy and recognizing it here in our workplace. And so the definition that we've provided is that bullying would be considered any abusive conduct of the employer or employee in the workplace done with malice that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interest. So to break this down, it's conduct not only by employees and how they treat one another, but also conduct of management and supervisors and their interaction with subordinates. It's conduct that really has to be done with malice. So we're not talking about, the day-to-day annoying behavior or instances where people don't see eye to eye at work. We're talking about the type of conduct that's done with ill will, with malice or in a malicious way, that a reasonable person would find hostile, offensive. And then this last piece is important for the individuals in this room because we have defined bullying as conduct that is completely unrelated to the employer's legitimate business interest. So if you have an employee who's absent 8 times in a row, you have to address that through discipline. And in the training that I've given to rank and file employees, I'm letting them know that's not bullying. Your supervisors engaging in legitimate business counseling or corrective actions, that wouldn't be considered bullying because that's tied to our legitimate business interest. People need to be here, they need to be at work, we need to be able to operate. But it really is the other stuff, the other malicious stuff done with ill will to intimidate, cause people to be offended or instill fear in them. Okay, so what does bullying include? I've provided your employees with lots and lots of examples of the type of conduct that could constitute bullying, but it includes what you would think it includes. It's the verbal abuse, it's the physical conduct that's threatening, intimidating, humiliating. Some of this conduct, frankly, could constitute not only bullying, but also what would be considered illegal harassment in the workplace, and we'll talk about that in a moment. But even just the day-to-day rudeness, if it's done intentionally, targeted toward one individual, day-to-day rudeness, belligerence, the public humiliation, screaming or cursing in the workplace, employees often report their supervisors or bosses for screaming or cursing, and at any given time, it is an element of one lawsuit or another that I have on my caseload, because even as benign as screaming or cursing appears, employees do feel that it is a form of bullying and harassment, and certainly it's a conduct that the courts have to contend with. Being arrogant, being quick to criticize and slow to praise. So I have a 6-year-old and a 2-year-old, and we work at home on positive reinforcement at that age. I am often quick to criticize and slow to praise. It's hard sometimes to find good things that they're doing to reinforce, but this is applicable also for your workplace. Be mindful of your subordinates and not just pointing out when they're doing things wrong, but also celebrating when they're accomplishing milestones that they should be meeting. Yes, sir. This one?
What is gratuitous sabotage?
So sabotaging employees. So it could either be.
I understand sabotage. What does gratuitous part? I don't understand gratuitous.
Yeah. So the gratuitous means that you're really just doing it aimed at one person, right? So it's not that a project or an idea maybe isn't valid or one that the company can undertake, so you're putting it aside. It's not that, right? We would consider that to be related to a legitimate business purpose. We don't have the funding for this now, so we're going to put that aside. The gratuitous sabotage is, maybe we have the funding for it, maybe it's a great idea, but I'm after this person, so I'm going to sabotage that. So that's more the example here, what we would consider bullying. Great question, thank you. All right, so quick to criticize, slow to praise. As managers, it's well within our ability to ensure that we are treating employees in a way where they're feeling motivated and positively reinforced and not always as if you're coming down on them. Other examples of bullying, obviously destruction of property. This is something that potentially would even be actionable that we would have to raise against an employee for destroying property. Spreading false rumors, gossiping. If you as a manager hear employees gossiping in the workplace, under this policy you have an affirmative duty to address it, to make sure that you let the employees know that it's not appropriate, it's prohibited under the bullying policy, under the harassment policy, and that they're not to be gossiping at work. So you have to be empowered and prepared that when you see this, if you should ever see this type of conduct, even something probably as common as workplace gossip, that you have to step in and address it. Stop it, exactly. So if you hear employees gossiping about one another at work, under the policy, as managers, you have a duty to stop it. You're on notice, legal notice, that it happened. If you're ever on the stand and you're deposed later in a case, should one ensue, and you're being questioned about whether you heard those rumors, and if your testimony is yes, and you can't defend that you then stepped in and addressed something, that would be problematic for the company. So absolutely have an affirmative duty. If this conduct is going on in your presence, you as a supervisor or manager are agents of the company, and you have a duty to affirmatively step in and stop it. And it could be just as simple as stepping in and letting an employee know, hey Dave, you're not supposed to be talking about those things at work, get back to work. Okay?
So does that mean it has to be documented? You have to document that?
Well, I think a best practice is always to document that type of conduct. I mean, if you see somebody engaging in some of this more benign conduct and you address it right there and then, I think it would be appropriate to keep a log and document it, but you don't need to, some of this stuff on a first offense probably doesn't warrant a coaching or a formal write-up. And when in doubt, you've got great resources in your human resources department, and so I would always, when in doubt, pick up the phone and drop in and visit Teresa or Michelle about questions like that. But that's a great question. Other examples of bullying, one particular to this group, is giving people arbitrary assignments, also instructing others to stop working, stop talking, or socializing with the target. So what happens, and I don't need to see a show of hands, but what happens is, as a supervisor or manager, if you find yourself with a problem employee on your team, someone who always raises concerns or complaints or is always out for various reasons, sometimes what happens in the team is everybody, including the manager, will occasionally decide to sort of distance themselves from that individual. You don't want to be the subject of their next complaint. You don't want to be roped into whatever they're alleging is going on. So sometimes the managers and the employees will take a step back. And in doing that, it actually creates an environment where that individual could now be feeling alienated. Supervisors are routinely accused of even engaging in retaliatory conduct for doing just that. And we'll talk a little bit more about retaliation and what that could look like for this group later in our presentation. But just be mindful that instructing people not to talk to someone, not socialize or not work with them, kind of that alienating behavior could certainly feel like bullying to the employee who's the target there. And then spying, stalking, micromanagement. Micromanagement comes up all the time. We hear it in EEOC charges, in lawsuits, that all of a sudden after someone has raised a complaint, now they're being micromanaged and they feel, that that's a form of harassment. Certainly, we would defend the company against that, but know that individuals perceive micromanagement as a form of bullying. Lying, intimidating, instilling fear, forgetting to invite some employees to work or social events. So if you're in the habit of taking your team to lunch, be mindful that you're inviting everybody and you're not excluding anybody from that invitation, right? Those individuals who aren't being invited certainly could feel left out, and if it falls along protected classes, could give rise to some sort of complaints. So what are the consequences? Bullying is very broad. We went through lots of examples. We went through the statistics showing that people believe it's happening, and in fact it likely is. But what are the consequences? Why, aside from the statistics, why else would we want to eliminate it from the workplace? And the reason is, look at all these consequences. For the alleged victim themselves, the individual could, have all of these physical manifestations of the stress, leading to them not coming to work, them not performing their job. Now they have, increased tardiness or absenteeism. For the company, now we're dealing with higher turnover, morale's gone down, production goes down. So these instances can have very real consequences, not only for the victim, but also for the company. To the extent we end up in a lawsuit where the company is named, you're individually named, your marital community is named, because we're in Arizona where we are a community property state. Certainly it would be a consequence that we would want to avoid. And all of that at the end of the day is just a waste of money and resources in having to address that. So for all of those reasons, based on the statistics and the consequences that are very real, we're committed to a no bullying culture, and we expect that to start at the top with each and every one of you. So we're committed to not engaging in bullying and also not tolerating other individuals engaging in bullying at the workplace, a commitment to stopping it if you see it. And you should know that we're encouraging employees to report bullying and other forms of harassment. That's part of the training. In fact, it's an essential element of any training that would be approved by the Equal Employment Opportunity Commission, is that employees are given appropriate channels for reporting concerns. And so what that tasks you with in this room is, if you receive any complaints or concerns that employees feel they're being bullied, harassed, and they don't have to use the magic buzzwords, although they often will. They'll often say, I'm discriminated, I'm harassed, I'm bullied. But even if they don't use those magic words, even if they just come to you and complain about the way they're being treated and feeling that they're being treated unfairly generally, that should put you on alert that you are now on notice of a potential claim that would be covered under the policy, possibly even covered under law, and that you need to raise it straight with human resources. We'll talk a little bit more about what else to do with those complaints. But please know that as a company, we must take all complaints seriously. It's all for naught if we unveil the policy and if we invest in the training and then people raise concerns, which they often do. After we do go through the workplace and do these types of trainings, we often see sort of a resurgence of or an uptick of claims that are raised with HR, and that's a good thing. We want all of that stuff to surface so that we can address it and put that to rest. We don't want things to fester, but it would be all for naught if people raise those concerns and we did nothing to take them seriously or address them, right? So we know that bullying is not illegal, but we know that harassment is. And so what happens is sometimes this bullying type conduct can overlap with what would legally be considered harassment. And therein lies the problem for the company, right? So some of it is just prohibited under our policy, we'll address it with appropriate discipline, but to the extent that some of that conduct also overlaps with what would be actionable claims, that raises potential liability for us. So let's talk about some recent cases, and I did not present these cases to your employees. These really are cases that I think are important for managers to get better perspective on, well, what types of fact patterns are out there and what are the consequences. So here's a case. This was brought by the EEOC, and you should know that in the current climate with the Me Too movement, that the EEOC has increased its enforcement resources tenfold. And so they are now filing claims against companies by the dozens. We're specifically focused on sexual harassment and these types of claims. But here's one where the EEOC sued the National Education Association, and these are the facts. So a group of female employees got together and they complained that their male supervisor was screaming at them. So that would violate our bullying policy, right? But it sounds relatively, benign. Using foul language, we know that happens in the American workplace, and was invading their personal space and using threatening physical gestures. So that's the extent of what he was doing. He wasn't trying to do what we would think of more traditionally in terms of sexual harassment. He wasn't, trying to grope them. He wasn't propositioning them sexually. He wasn't making lewd comments about them. And he wasn't using gender-specific terms. But in any event, this case went to court. And what do you think happened? Do you think that the judge allowed it to go forward to trial or threw it out just based on the facts of the case?
Threw it out.
You think he threw it out? No, he didn't. And I didn't plant that answer earlier. The court determined that the offensive conduct, it could violate Title VII, right? If there was sufficient evidence of qualitative and quantitative differences between what was being directed at the females versus what was directed at the males. And so even though the underlying conduct itself was relatively benign, not appropriate, certainly a violation of our policy, but it was screaming, using foul language, and not sexual in nature, the court said, if there's enough of a difference between how men and women are treated, this is a problem under Title VII, and that case went forward. All right, here's a more egregious case. This is a case about a retail clerk whose name was Osama Saleh. And this individual was repeatedly teased by a supervisor who would call him Saleh bin Laden. He told him he hated Arabs, they were dirty. He told him he should go back to Yemen. It ultimately escalated to the extent that there was a physical altercation and Saleh's cheekbone was broken in this. So pretty egregious facts, right? So we're now kind of on the other side of the spectrum. But what is interesting about this case, and the reason that I raised it in this training, is this store manager, who the complaints were raised to, basically ignored them and said, you know what, this is just banter. This is just kidding around. And the store president said, being called Bin Laden, that's not a big deal. It's just a name. It's just a joke, right? What do you think happened with this case? The jury went to trial, and the jury awarded him $4.7 million. And granted, you did have that physical element where his cheekbone was broken there, but awarded him $4.7 million. So what this case reveals is this could have been entirely prevented. This employee came forward and raised these concerns, and if the company management and HR had taken it more seriously and nipped it and addressed it, this case, likely could have been remedied short of this $4.7 million judgment. Okay, here's another case. This is Shapurian versus Mercy General Hospital. And in this case, the employee was a cardiac surgery assistant. So she was in the surgery room for these open heart surgeries. And over the course of 2 years, she raised 18 complaints about her employer. Now, the conduct here really is more along the lines of what you would think of core sexual harassment. So they were talking about their sex life and the surgeries. At one point, someone slapped her on the backside. They called her a stupid chick in the operating room. And granted, she's a highly educated cardiac surgeon assistant. The supervisor had supposedly witnessed this and turned a blind eye, in particular because one of the individuals primarily engaged in this conduct was a very lucrative cardiac surgeon for the hospital. And so shortly thereafter, she gets fired. Now, there's always two sides of the story. So the company or the hospital said, we fired her for sleeping on the job. We also had called her on on-call shifts and she never showed up. So that was our legitimate reason for firing her. She claimed I was fired because I had raised so many complaints. And it really was an excessive number. Over the course of 2 years, it was 18 complaints. So she files a lawsuit against the company, and she also filed a claim of retaliation, which is the type of claim filed with the EEOC that is increasing the fastest over any other types of claims. So there's a retaliation claim that piggybacks on almost every piece of litigation that I presently touch. So she had a retaliation claim, and in her case, when the hospital fired her, they terminated her privileges to come in and work at the hospital, and so she wasn't able to get a subsequent new job because of that, and she filed that was retaliation on top of the harassment. So the case goes to trial, and has anybody ever sat on a jury before? Okay, so part of that process for anybody who's ever sat and maybe gotten through the entire process is once the jurors are deliberating, if they want to communicate with the judge, they can. The bailiff will come in and they can write a statement. It's basically like passing notes. So the bailiff will come in, they'll write the statement, it goes out to the judge will respond, and the note comes back. And so they filled out that questionnaire for the judge, and this is what they asked. So for anybody who can't read, what it says there is, may we please have a calculator, okay? And what do you think who won? Clearly she did, right? The employer doesn't get any, recomps of damages there, so clearly if they were calculating something, it was for her. And what do you think the amount was? $168 million. And the court said, no, that's unreasonable, jurors. And the judge just reduced it down to 82.3, but still an incredible amount. You can see what a breakup of it was. So for Title VII, she only got $300,000. So that would be, what the back wages and compensatory damages were. But for the punitive damages, the damages that are specifically awarded to punish the employer and set an example so other employers don't behave in this way, $56 million. I mean, that's, unbelievable considering what her true damages were. So the moral of these cases is perfectly preventable, judgments against the company. When these employees are raising these concerns, you have to take the concerns seriously, however silly they might sound. It's just name calling, it's just joking, or however valued the individual is who's involved in the conduct. So it's very easy to commit to being behind bullying prevention and harassment prevention in the workplace. But what it actually means is if you find out through an HR investigation that it's happening, the company has to be committed to addressing it. And sometimes, even if that means terminating your star player, at a critical time for your organization, that's what's required. And these are some of the consequences that can ensue. Now, granted, this is California case, but this is what we're seeing in this climate. This is what we're seeing. So the laws addressing sexual harassment is prohibited under Title VII. That's what some of the cases are that we just reviewed, and also under state law, both in New Mexico and Arizona, in addition to under local laws. And what is sexual harassment? So kind of to move into the second part of the training is, we've covered the bullying, we've looked at some examples of it. Now let's drill down a little bit more into the sexual harassment and what your obligations are under the policy. So sexual harassment is just a form of sex-based discrimination. And discrimination is prohibited at the federal level under all of these various laws, Title VII being the primary one that was passed in 1964. And it prohibits discrimination against race, color, national origin, religion, sex, including sexual harassment, a form of discrimination based on sex. Also prohibited is discrimination against pregnant women under the Pregnancy Discrimination Act. The ADEA prohibits discrimination against any individuals who are over 40 years of age in the workplace. Americans with Disabilities Act requires that qualified employees who are disabled be provided with reasonable accommodations to help them perform their essential job functions at work, so long as it doesn't cost us an undue hardship. And that determination is really one, if you ever find yourself with an employee who may or may not be disabled or qualified for a reasonable accommodation, that's really something that you should work closely hand in hand with HR to address. Also, GINA prohibits genetic information discrimination, and USERA protects military members in the workplace. So what is harassment? Certainly the cases that we saw included some form of harassment. And I put this slide both in your training and in the training that I give your employees to illustrate an important point, which is not everything is harassment in the workplace. Not everything's going to give rise to a $4.7 million judgment, right? In order for it to be actionable, it has to meet all of these elements. It has to be unwelcome, offensive, sexual in nature, pervasive and severe, and alter the work environment. You could substitute any protected category. If we were, instead of sexual harassment, if we were talking about harassment based on someone's religion, it would just have to be religious in nature, the conduct. But I illustrate this slide because I want folks to understand that even though conduct is very broadly prohibited under your policy, the policy is broad on purpose, because we want to nip conduct so that it never rises to being severe, pervasive, and offensive, and altering the work environment. We want to nip this type of conduct and comportment in the workplace so it never rises to the level of being actionable. Okay? Examples of sexual harassment. This is exactly what you would think of. It's the unwanted sexual advances, displaying sexual objects, talking about people's body, clothing, appearance, touching, making derogatory remarks, name calling. Some of this could also be bullying. The name calling could be bullying and harassment. Leering or elevator eyes. If you see people doing that in the workplace, you have to jump in and tell them to stop. You can't have one employee looking another employee up and down and just walk past and not address it. You must address that kind of conduct. And then these bullets here, the last three bullets, sexual advances or promises to advance a career in exchange for sexual favors, or demoting or threatening reprisal after somebody declines a request for sex. Those three bullets are exclusively within the hands of everybody in this room. So employees cannot demote one another. They can't advance one another's careers in terms of promotions or positive evaluations. That's conduct that an authority that really falls under your job description. And so as you'll see in a moment, because as supervisors and managers, you have extra authority in terms of affecting people's day-to-day terms of conditions of employment, we also as a company face a heightened liability if the conduct is coming from you versus if it's coming from fellow coworkers. Other examples, spreading rumors. Again, if you see it, if you hear it, you have to step in and stop it. And then the unwanted physical conduct, touching, petting, kissing, hugging. Generally a good idea not to hug subordinates or touch subordinates. over the years, I've seen complaints where employee gets written up, becomes disgruntled, and then HR's hearing about the fact that, the supervisor touched or hugged employees in the past, right? Not an uncommon fact pattern. And then anything sexual jokes, sexual conduct, sexual emails, anything sexual in nature would obviously be prohibited. Okay. As supervisors in today's workplace, we need to be cognizant of harassment taking place not only between people in person, based on what they're saying to one another or physical conduct that they're engaging in the workplace, but also over all these other forms of social media. So are they harassing one another over Snapchat or Instagram or email? And certainly if you hear about that, your first line of defense is to go straight to HR and let them become involved. You don't want to, pull up someone's Facebook page yourself and try to do that investigation. So the EEOC every year, the Equal Employment Opportunity Commission, responsible for ferreting out harassment and discrimination in the workplace, they put out a study, and in 2016, their study indicated that anywhere from 25% to 85% of women reported having experienced sexual harassment in the workplace. For men, it was 15%, and for LGBT, it was 58%. And these numbers are alarming, knowing that harassment has been illegal since 1964. However many years later, here we are, and the numbers are still, and particularly now, in this current climate, there has been a significant uptick. So in 2017, to break it down a little bit further, the EEOC reported that the types of charges they received, of those types of charges, 25,000 were for sex discrimination, 6,600 were specifically for sexual harassment. And they like to brag about how much they recover from companies. So this was their figure in 2017, $46.3 million that they themselves will go out and recoup. And so the way that it works, just in broad brushstrokes, is if an employee, before they can file a federal lawsuit against you for any claims protected under Title VII, they first have to go to the EEOC, file a complaint. We have an opportunity to mediate there if we want, or we just provide our response. The EEOC investigates. Sometimes, more often than not now, employees' attorneys will say, don't bother with the investigation, just give us the right to sue. We're going to sue them anyway. And so they get a notice of right to sue. They're required to do those preliminary steps. If the EEOC likes the facts and decides that it's one that they think they need to address, they will sue the company in tandem with the employee. Otherwise, they'll dismiss it and give the employee a right to sue. They'll go out and find their private attorney, and then they're off to a lawsuit. That's generally how the EEOC process works in a thumbnail sketch. Now, I bet a steak dinner at one of the manager trainings that I did in Albuquerque that we were going to see these numbers go up. And I don't know who, but somebody owes me a steak dinner, because last week the EEOC reported that they have received a 50% increase in the number of harassment suits that are being raised. And so that we knew that number was coming, and it really, it doesn't surprise me. All right, so different types of harassment. The worst and most egregious type is quid pro quo harassment. We are automatically liable in these instances. And quid pro quo is just basically this for that. You sleep with me, I give you a bonus. You don't go out on this date with me, I'm going to give you the bad shift. It's this for that, affecting tangible terms and conditions of employment. Again, it's nothing that coworkers can affect for one another, because they aren't authorized to terminate or write up or give people pay increases, and so it exclusively is in the hands of individuals in this room. And then a less egregious form where we could have an affirmative defense that we can raise is generally hostile work environment. In that case, we can raise a defense to the extent that it wasn't conducted by a supervisor, and we have a policy against this, which we do. We are investigating it, which we are committed to under our policy, and that means not that you're investigating it, but that you're getting it straight to Michelle so she can investigate, and that we're taking appropriate action, which we're committed to doing. All right, so the quid pro quo. Because of your control over subordinates, you are in a position to cause the company liability under this type of harassment. Even though it's consensual, and sometimes this is often the fact pattern, even though the conduct initially is consensual, at some point it ceases to be consensual, it becomes unwanted and coerced, and off we are to the races. Okay. And hostile work environment, just generally to give you a definition, it's again that unwelcome, severe, pervasive conduct that creates a hostile and abusive working environment. We will be liable if we knew or should have known about it and failed to take any action to address it. So this is a slide that I've included in the presentation for your employees, and it just basically illustrates that our obligation to our employees under Title VII is to provide them with a harassment-free work environment, regardless of which direction the harassment's coming from. So obviously, you shouldn't be harassing your employees. But even if it's coming from customers or vendors or other contractors who are on site, we are still responsible for prohibiting that conduct. And then I teasingly told them that really these arrows should go both ways. They should not be harassing you, so hopefully that's not happening. All right, this next slide illustrates the liability. So we can have a defense based basically on a negligence standard if harassment occurs in the workplace, but it doesn't occur from the top down. It happens among coworkers, not something that the supervisor imposes on a subordinate. So in that case, if your coworker or if your employees are harassing each other, and if it is severe and pervasive, but we nonetheless knew or should have known, and the minute we found out we took appropriate action to address it, we can avoid liability there. Higher standard of liability if now the harassment is by a supervisor. If the harassment is by a supervisor, we're going to be vicariously liable, which means we're automatically liable, unless we can show that we had a policy, we took the appropriate steps to investigate, and the employee failed to avail themselves of those protections. And now the red zone, this is where we definitely want to keep all of our managers out of, is if you as a supervisor are engaging in harassment that results in a tangible employment action. So we're talking about the quid pro quo, the this for that, or you in retaliation for some sort of rejection of sexual demand, you fire somebody, you demote them, you give them a bad shift, you all of a sudden stop taking them out to see customers or inviting them to the group lunches, then we will automatically be vicariously liable, and there's no defense that we could raise. So we would just be getting out our checkbook and negotiating, to try to get that dollar amount down as much as we possibly could, because we know that we would face a strict liability in court. Okay? And each and every one of you are in a position to keep us out of this bracket of liability. So a few more court cases. What is a tangible employment action? So remember, if it includes a tangible employment action, we're automatically liable. Well, what does that include? It's what we've been talking about: demotions, promotions, bad evaluations, changing shifts, all of that. But also, there's this case that was filed against Chase Bank Card Services where an employee had to go talk to a diversity officer and was asked questions about her sex life. She divulged information that she found to be embarrassing, right? So this shouldn't be happening, but it did, okay? And she goes to the supervisor and says, I'm not comfortable, I don't want to have to answer these questions. And the supervisor says, well, I can't do anything about it, just go back and finish, basically finish the survey. The court held that her terms and conditions of employment, by being made to go back and finish that inappropriate survey that shouldn't have been happening, that altered the terms and conditions of employment. Okay, so it's definitely the demotions, the firings, but it's also subjecting folks to this type of conduct just generally. Another case, important to note, yes, federal courts do not prohibit discrimination or harassment based on sexual orientation, but the trend nationwide is for that type of conduct to be prohibited along the lines of sex-based discrimination, and certainly that's the direction the EOC is moving on, and that courts across the country are moving in. So this was an example about a male employee who was made fun of and repeatedly called names. In this case, he was called Sing-a-ling, a reference to a homosexual character in this movie, Life. So he was called these names by other males at work. So male employee, other male employees name-calling him based on his sexual orientation. And the court held that even though sexual orientation isn't protected, this was still sex-based. Even though they didn't have a sexual desire, they weren't teasing him because they wanted to make advances on him or were attracted to him, that's not the standard. In this case, it was based on his sex, and that was enough to go forward. So that's certainly a trend that we're seeing the courts take. And then this Burlington Northern, this is not a newer case, but it's an important case for managers to know. In this case, there was an employee forklift operator, and she reported sexual harassment. In order to address the situation, the company moved her and reassigned her to another position. She raised this with the court. It went all the way up to the Supreme Court, and the Supreme Court found that moving her, reassigning her, was a material adverse action to the employee. In that case, she shouldn't have been moved. Whoever was engaged in the harassing conduct, they should have been moved. So even that can be a form of altering someone's terms and conditions of employment and retaliating against them. So even though we know there are appropriate and legal routes for raising these complaints, we know that they go unreported. We know that because of this individual who's celebrating an anniversary this week of the anniversary of when allegations against him started to be raised. So everybody recognize who this is? Harvey Weinstein, yes, Harvey Weinstein. So Hollywood media mogul who over the years had settled numerous sexual assault and sexual harassment complaints. He settled them, paid them off, kept it quiet, and then after many, many years, complaints started to surface one after the other, and it really ignited what we're now presently in, which is the Me Too movement. Has everybody heard of the Me Too movement? Its usage worldwide has tallied now at up to 1 billion times that someone has posted hashtag Me Too on a social media site. And so essentially indicating that they too have been alleged victim of some form of harassment or assault. And so it started with Hollywood, but it has spread into every industry imaginable. It now includes politicians and journalists and athletes and comedians and actors, and I don't know who else you recognize up there, but you name it. There really is not a work of employment that is not potentially at risk for Me Too-like allegations. And from a company perspective, what's scary about these is now we're not just talking about a single lawsuit, but we're talking about a lawsuit where there are class and pattern allegations being raised. So we might not just have one plaintiff, we might have one plaintiff and 5 Me Too plaintiffs or witnesses who also allege they've been engaged against that conduct. And so, and also what's very damaging is the fact that these are being fought on a social media front. So even if the claims are utterly baseless and we feel very confident about getting them dismissed for you in court, what we're seeing is tangible damage to the company's reputation, to customer accounts, to ability to do business, because these allegations are being posted in social media as if they were true, based on just the mere complaint, even if judgment is never ultimately found. And so this is, very significant change in the landscape for how we're defending these lawsuits today. And some psychologists have weighed in terms of, well, why do individuals engage in this conduct, and how did it get so bad, essentially? And what they've reported is this type of harassment is often used to intimidate, disempower, or discourage women in traditionally male-dominated industries, which are, many or most industries in the United States. And these issues of entitlement, power, and control, if they go unchecked, then these situations exist where individuals feel it's perfectly fine to engage in this type of behavior. And so that's, from a psychological perspective, well, how does it get that bad? It's because it goes unchecked in the workplace. And so we're training employees that they must report it. It's not discretionary, it's mandatory. If they feel that they're being harassed or bullied, they must report it. And so the flip side of that is if they raise it to you, you must let HR know and senior management know, because now we are all on notice about the conduct, and we won't be able to raise any of our defenses to the extent we have them if we're not taking appropriate steps to address it. So, it's not good enough for us that we don't have any Weinsteins in our workplace. We want to move the standard not just from what's illegal to legal, but get everybody behaving in an ethical way. So we want this to be a very positive working environment. We want your employees and you to be treating your employees with dignity and respect. The very first sentence in your harassment policy talks about respect for employees, and so that's the ultimate goal. Now, as a manager, supervisor, and some of these are a bit exaggerated, but as a manager, supervisor, you should know that what you say carries significant weight for your employees. If they said it to one another, they might not feel as if it was as offensive as if it came down from you. Because remember, you're the boss. You're the person who's going to be setting raises and evaluations and assigning schedules. And so when you are interacting with your employees, be very mindful about whether you're saying things in the best way that you possibly can. And then these are, funny examples. In this case, a good example when the supervisor is coaching the employee was, "Thanks for discussing the topic and listening to my concerns." Not so good. "I'm very impressed you keep your composure. Lots of women cry when they're told they've missed the mark on the project." Now, these examples are a bit exaggerated, but they really illustrate the point that there's a better way to deliver messages, particularly where you're delivering corrective action or other discipline, performance improvement plans. A good idea to work with HR and make sure that the message is appropriate before going into that meeting. Same thing with terminations. Make sure that your messaging is appropriate before you go in. Because employees may not be hearing what you're saying. They might be hearing something more along the lines of this. And at the end of the day, harassment is not measured from the perspective of the speaker, but from perspective of the listener. Okay? So your intent to not offend people is not going to be relevant to that defense. I can't tell the judge, "Sorry, judge, he didn't mean anything by it," or "She didn't mean anything by it." That's not going to be a good defense for us. All right, just a couple more cases as we round out the presentation. In this case, this was a case by a female associate, a lawyer at a law firm, bankruptcy law firm, who claimed that she was being discriminated against and sexually harassed. And she reported it to her mentor, that a specific partner in particular was subjecting her to that conduct, and the advice was, well, just avoid him as much as possible. She then said, well, she wasn't given the same types of opportunities to advance. That male associates were given better work assignments. They were allowed to get better bonuses. While the women were given disproportionately more non-billable work. So do a presentation, write an article, the things that we don't bill clients for. Not this one. And the males would get to go out on, and have client contacts. So they would go on golf outings together, and they would have networking opportunities with one another where some of the women weren't. So she said, when I complained about this on multiple occasions, I was told, listen, change at the firm's not going to happen overnight. You're looking for systematic change, and that's just not going to happen. And so this individual ultimately filed a lawsuit. It settled out of court for an undisclosed amount, so we don't know what that amount is. But you can imagine that working at a firm, she was obviously compensated here. So the takeaways from this case are, it was, conduct that fell along the lines of gender. So males being given better opportunities to have billable work, choice assignments, contact with clients, while the women weren't. And that could fall in your workplace along any lines. The better projects are given to the younger employees, whereas the older employees aren't being given the good accounts. It could fall under any protected category, not just gender and sex. But be mindful as a supervisor when you maybe have your eyes set on someone who you're grooming for some sort of succession planning, or who you think might be a good next lead for your team, that you're very mindful about, am I being objective? Am I being fair? Would I be perceived, or worse, misperceived as having some bias, some race-based or gender-based or sex-based bias against individuals? Because these fact patterns, definitely work their ways into the courts. And in any event, studies have found that when we have mixed gender teams, that it increases performance significantly. So what's an employer to do? A couple of practical tips. What's an employer to do, for example, when people date in the workplace? What would you do if you have employees dating in the workplace, they're dating? What do you do with that? Okay. Whenever you have that feeling of, I don't know, I do not know what to do, where do I even start with this? I don't want to touch it. Follow that instinct and just pass it off to human resources, right? So I joke that that we don't want Michelle running the reactor, right? And we probably don't want our managers and supervisors trying to, handle HR. Everybody has a specific, skill set and training to their, based on their assignment. And so Michelle, Teresa, they are our HR experts. They really are insurance for the company, insurance for managers and management to keep us out of trouble, because they do know how to handle these complaints. So we should rope them in immediately. So if you have people who are dating on your team, I think the appropriate thing is let them know that they need to go see Teresa or Michelle in HR. What about alcohol in the workplace? You may not have many instances where there is alcohol in the workplace, but just be mindful that it obviously affects people's judgment, and although the environment might be more casual, you are still the boss. You never take that hat off. I joke in some of these trainings that, how do employees feel when they see their boss at the grocery store? Do they feel like, oh, hey, Bob, or do they feel like, oh, hey, boss? And it's always the latter, right? You are always the boss, even outside of work, even at social functions. You're still viewed that way through that lens. So how do we prevent harassment? For everyone in this room, it needs to really start top down. So you should be setting model example of the type of comportment that we expect. If people see you cussing and yelling and engaging in banter and fun, that means it's that's perfectly acceptable for everyone else at work. So you start by being a good role model, keeping an open door policy. If people are coming to you for complaints and you want them to raise a complaint, sometimes managers complain. They say, well, the employee didn't follow the chain of command. They went over my head. They didn't come to me first. And my response to them is, listen, I'm not so concerned with whether they came to you or your peer or your competitive, co-senior staff member or your boss or HR. I'm concerned with whether they went to the EEOC, a lawyer, right, or social media and took it up there. I want them to start inside these the four corners of our company. And so regardless of where they're going, I always joke the dolphins will get free, right? So if the claim is false, we'll get to the bottom of it, not to be concerned. But it's more important that people feel that they can raise concerns and that they do raise concerns and that we address them, rather than that we get too hung up on the fact that they didn't follow proper chain of command. So also, we as a company are obligated to investigate every complaint of harassment. And when I say we mean Michelle and Teresa. Okay, as supervisors or managers, if you get a complaint, please do not try to collect information. Don't try to get statements. Don't try to do any due diligence before you package it and present it to HR. All of that could be done incorrectly. I wouldn't know the first button to touch on the reactor, right? So same thing, just immediately turn it over to Michelle, and she'll figure out who needs to be interviewed and what the appropriate investigation scope is and how that looks. So turn it over to her immediately. Please know that potential retaliation claims can arise even if there's not an underlying claim. So the claims for harassment might be completely bogus, or the claims for bullying might be something that wouldn't even constitute a violation under our policy. But the actions that we took against the employee after they complained could incite a retaliation claim. And so that, everybody will don't talk to them, give them space, don't work with them, that could be viewed as retaliatory. When people are out, I think it's worth saying, when people are out on job protected leave, whether FMLA or pregnancy leave or whatever job protected leave, you also want to make sure that you're not engaging in what could be perceived as retaliatory conduct against them. So they call off and you sort of express some sort of discontentment with it, or employees in your group roll their eyes, or they're out again, that kind of stuff. Because again, it's the individual engaging in conduct that's protected, either because they have a right to complain, because they have a right to the leave, whatever they're availing themselves to, that's legally protected. And if we interfere with it or take any action against the employee, could be viewed as retaliation. And these retaliation claims are on the rise, like I said. All right, if the complaint's about you, you will have an opportunity as part of the objective investigation to provide your side of it. The investigator will look at both sides and make a determination. Ultimately, if you did nothing wrong, you're going to be fine. But please do not retaliate. Do not try to talk to the witnesses yourself. Do not try to confront the individual who raised the complaint. Don't try to have others in the workplace do it for you. It really, if a complaint is raised against you, you really should be following HR's instructions to a T in helping to get the company out of that. Golden rule, don't make that comment, tell that joke, or say that statement if you wouldn't want to do it in federal court before a judge and before a jury of your peers, right? That's the golden standard. It used to be the grandmother standard, but then the grandmothers in the U.S. became liberated. All right. Okay. And if you feel that you're bullied, please know that, yes, this training was geared to you as managers and supervisors, but you are nonetheless employees of the organization as well. And so all the protections that I provided in the training for your employees, those apply to you as well. You have a right to be in a harassment-free environment, to be free of bullying in the workplace. If you feel like you are being harassed or bullied, don't keep it to yourself. Please report and know that they're, just like you can't retaliate against your subordinates, you cannot be retaliated against for raising these types of concerns. So if you have them, please raise them so we can address them. And then, of course, there's your local HR contacts for those concerns. Any questions?
I just want,
Yes.
of the complaints to the EOC,
Mhm.
are a lot of them dismissed, or are they almost all prosecuted, or there's some?
Okay, so knock on wood, but over the 11 years that I've practiced, I've never had a complaint not get dismissed from the EEOC. So by and large, they all go away, and the EEOC recognizes that they get a lot of, very frivolous complaints. I mean, they do have a process, and they try very much in the intake process to ferret out those allegations that don't even meet very threshold issues. But even so, they just have such a high volume, and the majority, I don't know that they've ever reported how many they throw out, all of mine. But I think the landscape is changing. So frankly, I was just discussing with some colleagues yesterday how the courts in today's landscape are going to be less inclined to throw cases out in summary judgment. In fact, California just passed a law where sexual harassment claims cannot be thrown out at summary judgment. They have to go forward to trial. So I think judges nationwide are going to be, more cognizant of these liberal standards and more likely to let cases go forward to the jury and have the jury, hash out those facts than before. And so I won't bet a steak dinner on that one, but I am watching our Ninth Circuit Judiciary to see how they respond to these cases. And it's definitely a good time to train. It's a really important time to go above and beyond, like SUMCO did in adding the bullying piece. And if you have questions or concerns that come out of this training, just send them all to Michelle. We don't keep her busy enough anyway. Thank you so much.